Your search for the most comprehensive CLAT preparation program ends now. BYJU'S Exam Prep brings to you over 300 recorded lectures, 300 plus hours of live classes, over 50 mocks across CLAT and non-CLAT exams, and 9,000 plus topic specific preparation questions. All of this specifically curated by NLU alums and IM grads. So what's stopping you? Go register for the BYJU'S Exam Prep scholarship test now and get thousands of scholarships.
A very good evening to all of you. So guys, today we are back with SLAT Marathon. Now, your Maharashtra CET is over, just over, it got over, right? Last week. Now, you have SLAT. That's an exam that is upcoming. And for this reason alone, for Symbiosis Law Admission Test alone, we are bringing up with certain very important session called SLAT Marathon. In this session, we shall be discussing certain questions. We are going to receive your answers from you, understand how to solve these questions, because these questions will be very important for each and every one of you. So if you are one of those who is sincerely preparing for SLAT, Symbiosis Law Admission Test, this session will be of great important. Okay, so guys, let's begin with today's session. But before we begin, we have certain questions that we have to solve as the agenda. Now, moving on to the next, before we begin, there are certain very important announcements. BYJU'S Exam Prep brings to you a free workshop on is it too late to start preparing for CLAT 2024, because 2024 will be in December 2023. So you are in the month of April end. You have May, June, July, August, September, October, November, 7 months, right? Then you have your exam in December. So 7.5 months, how should you prepare? So there will be a workshop on it on the 7th of May at 6 p.m. by Abhimanyu sir. Another very important announcement. BYJU'S Exam Prep brings to you a scholarship test. Get up to 90% scholarship on our preparation program. This scholarship test is going to happen on the 30th of April at 11 a.m. So hurry up and register now for the BYJU'S Exam Prep scholarship test. BYJU'S Exam Prep also brings to you, I'm sure you guys are all aware of it, CLAT 2024 comprehensive course. We are going to provide you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mocks for CLAT and other law entrance examination along with video solution, monthly e-magazine for current affairs, and the entire content is based on our extensive analysis in the last couple of years. So let's begin. The first question is up there on your screen. The first question is up there on your screen. Which of the following smritis is considered to be the oldest code in India? Oldest legal code. Is it Narad Smriti? Is it Manu Smriti? Is it Ved Smriti? It is Parsanath Smriti. Which of the following? The oldest code, the oldest legal code in India is the Manu Smriti. Option B is the right answer. Option B is the right answer, guys. So the legal code of Manu, which is called Manu Smriti, happens to be the oldest legal code in India. Okay, moving on to the next question, question number 2. Which of the following is another name for private international law? Now, private international law, I'm sure most of you are aware, it is not called civil law. It is not called local law. It is because civil law means our civil code inside the country. Local laws is within a particular territory. Common law is that law that India has also received from the from UK, right? England, the laws in England. So it is called the conflict of laws because different countries have different laws, right? Our India's contract law will be different from Japanese contract law. That is what is called a private international law. It is that law that deals with conflict of laws. Am I clear? So there is a law, private international law deals with conflict between citizens of different countries. There are legal system, every country will have their own legal system. So there is a conflict when we enter into a international contract, right? So different countries will have different rules. Moving on to question number 3. Question number 3 is up there on your screen. Transfer of an interest in a specific immovable property. Immovable property for the purpose of securing the payment of money advanced by way of a loan or a debt. So the question is, it has to be an immovable property. Bailment is movable. Perjury is saying something false in a court of law. So this. The confusion might be between mortgage and pledge. Pledge, movable. Mortgage, you mortgage your land. I am mortgaging my house. I am mortgaging something that is immovable. Is that clear? So the transfer of in a specific immovable property, very, very important. Over here, the most important thing is the immovable property. Am I clear, everyone? Is that clear to each and every one of you? Tell me. Am I clear to each and every one? Okay. If you're liking this session, do press the like button. There are around 22 people, 25 people who are watching me live. Okay. Okay, fantastic. Let's move ahead with the next question. Question number 4. Parliament in India is based on which of the following principles? Parliament, okay? Is it based on bicameralism? Is it based on universal adult franchise, diarchy, federalism? Our parliament, we are talking about the parliament. Voting in India is under universal adult franchise, 18 years of age. Now, the rule that is closely attached to the Indian Parliament is Lok Sabha, Rajya Sabha, bicameral legislature, the lower house, the Lok Sabha, the house of the people, and then you have the Rajya Sabha, house of the elders. Am I clear? Is that clear to everyone? Am I clear, everyone? This is how you will have to solve these questions. Moving on to the next question without any delay. Joint heirs to a property is called co-heirs, co-parceners, successors, and joint owners. Which are the following? Now, let me tell you the answer, because if you don't know this answer, it will be difficult for you. It is called co-parceners. Okay, it is not called co-heir. It is called co-parcenary property. Okay, it's the joint property of all the legal heirs. प्रॉपर्टी डिवाइड नहीं हुआ है, अभी भी जॉइंट heirs है. Am I clear, everyone? Everyone has equal right over the entire property. Everyone. Is that clear? सबको समझ में आ रहा है? सभी को? Moving on to question number 6. When a person is prosecuted for committing a criminal offense, the burden of proof lies on the police. The police has to prove beyond all reasonable doubt that the accused has committed an offense. Just a sec. Just a sec. Just a sec. I think there is some technical difficulty, but we will definitely continue with the class. I'll just give me a sec. 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 Okay. Okay. So guys, let's move on then. So let's start with question number 6 once again. When a person is prosecuted for committing a criminal offense, the burden of proof lies on the prosecution. It is on the prosecution. Am I clear? Every one of you. That means the police has to prove that the accused has committed a wrong. Is that clear? The burden of proof is on the prosecution. Am I clear? All of you? Is that clear? Everyone? Question number 7. A police officer can arrest a person without a warrant. In which of the following cases can arrest a person without a arrest warrant? The question is as simple as that. Now, murder, rape, dacoity. Now, these are cognizable offenses where the police can take cognizance, arrest an individual without arrest warrant, some terrorist. These are, the police has the power, has the authority to arrest an individual even without a warrant. Is that clear? Am I clear? Is that clear? It is arrest without warrant, cognizable offense. Am I clear? Those are murder, rape, dacoity. These are high offenses, right? Okay. Moving on to question number 8. A. Who is a pleader as per the Indian law? A person who is entitled to appear and plead in any court in India. Okay. A person entitled to be a judge and decide a case? No. Any person entitled to plead only for a juvenile under a special court? No. Any person entitled to hold a public office is called a pleader? No. The correct answer is option A. This is how you should solve. Read the propositions, read the options. You can eliminate some of the options by reading them. Am I clear? समझ रहे हो? By way of elimination also, by way of eliminating the wrong option, you will come to the right answer. Question number 9. Which of the following is not one of the fundamental rights provided under the Constitution? Right to religion, equality, privacy, property. It was taken away. It used to be a fundamental right at one point in time, but constitutional amendments were made, and by virtue of that, this right to property is today under Article 300A, Article 300A of the Indian Constitution. It is not a fundamental right as on today. Okay. Very important, okay? As I said, by virtue of a constitutional amendment, the 44th constitutional amendment, this fundamental right was removed from part 3 of the Indian constitution, and today it is just a constitutional right under article 300A of the Indian constitution. So keep that in your mind. Question number 10. A Consumer Protection Act was passed in which year? Now, if you know it, you know it. If you don't know it, you cannot eliminate wrong answers over here. If you are 100% sure that ठीक है मेरे को पता है, हाँ जैसे मैं बता देता हूँ आंसर क्या है 1986. The Consumer Protection Act of 1986. That is all we know. But if you have a doubt, leave this question. Okay. So it was passed in the year 1986 to protect the interest of consumers and customers. Okay. Can we move on to the next questions? Okay. Our question number 11 is up there on your screen. Which of the following is not a valid defense under the Indian Penal Code? Private defense, insanity, intoxication, ignorance of law is not an excuse. Is not an excuse. So if you are not aware of a law, it is not a defense. You should be aware of a law. Am I clear, all of you? Ignorance of law is not a valid defense in criminal cases under the Indian Penal Code, whereas private defense, insanity, intoxication, they are defenses under the criminal law. Question number 12. State shall provide free and compulsory education to children between 6 and 14 years as determined by law. This has been provided in which of the following articles? Okay, tell me. It's a very simple one. The right to education. The right to education comes under Article 21A of the Indian Constitution. So the correct answer is option D. Very good, very good. Most of you have done it beautifully. Okay. Article 21A, right to education. Very important. Moving on to question number 13. Which of the following is not a type of company in India? Okay. LLP, limited liability partnership, private limited company, cooperative society, all of the above. No, cooperative society is a society. It has the Cooperative Societies Act. There are different rules that the parliament has devised for cooperative societies. Okay, keep that in your mind. Okay, is that clear? So the rules are very different for a company and that for which is required for a cooperative society. Question number 14. A judge of the Supreme Court retires at attaining the age of... Yes, this is so easy. This is so easy. Never expected. High Court judges retire at the age of 62. Supreme Court 65. Keep this in your mind. Keep this in your mind. Do keep this in your mind. Very easy question. Not at all difficult. Okay, question number 15. Which of the following is not one of the legal remedies available to a victim in India? Injunction, you can go and get an injunction. Damages, you can seek damages. Yes. Compensation. Repudiation. Okay. Repudiation means you do not want to participate in a contract. No, all of the above. I think option C is the right answer. Let's see whether option C is the right answer or not. Yes, it is not a type of legal remedy available in India. When one party refuses to perform the part of his duty of a contract, that is called repudiation. That is not a legal remedy. You can claim injunction. You can claim compensation, damages. Of course, they are legal remedy if your legal rights have been violated. Am I clear? सभी को समझ में आ रहा है? Am I clear to each and every one of you? Am I clear? All of you? Okay. So guys, if you're liking this session, do press the like button. Do press the like button if you're liking this session. Moving on to question number 16. Oh, I think Supreme Court of India is empowered to issue which of the following writs? Habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Prohibition and quo warranto are the other two types of writs. Habeas corpus is given, mandamus is given, certiorari is given, prohibition and quo warranto. These are the 5 different types of writs. Is empowered to issue which of the following writs? All of the above. All of the above. Am I clear? Am I clear, everyone? Okay. Supreme Court does it under Article 32. High Court has the same power under 226. Am I clear? Very important thing. Please note it down. Am I clear, everyone? ठीक है, आगे बढ़ते हैं. Question number 17. Which of the following is not one of the principles of natural justice? Okay, audi alter partem, hear the other side. So when a judge is deciding a particular case, he hears both the sides. Nemo judex in causa sua, same. Nobody can be a judge in his own cause. Okay. Nemo dead, okay, that means you have to cause action. These res judicata, this is a principle in civil law, that if a dispute is decided by a court having jurisdiction, the same dispute, you cannot take it to another court. Am I clear? That is called res judicata. Res judicata simply means if a dispute is solved by a court, if you are not happy, you can definitely appeal against that order, but you cannot go from one court to the other and ask for the same remedy. Nobody can be punished for the same offense twice, right? Okay. This is a doctrine of civil procedure which prohibits the same matter being re-litigated between the same parties. So if there is a dispute between Mr. A and Mr. B that is solved by a court, I can definitely appeal before the higher court, but I cannot go on Bihar court, Odisha court, West Bengal court and filing the same thing again and again and again. Okay, I hope I am clear to each and every one. Okay, moving on to question number 18. Which of the following does not fall within the ambit of law of torts in India? Negligence, defamation, trespass. This is crime. It is not a civil law. It is theft. Very simple question. Very insanely simple question. Okay. Question number 19. What do you mean by the term caveat emptor? What do you understand by the term caveat emptor? It simply means let the buyer beware. So when you are buying something from the market, suppose you go to a market to buy some products. I went to the market to buy a pen. I should, before I buy, let me also, it's also my duty to check the pen. Caveat emptor. Question number 20. ADR is a way by which people can solve dispute without a trial. Absolutely. What is the full form of ADR? It's so simple. Alternative dispute resolution, ADR. It means mediation, conciliation, lok adalat, arbitration. Okay, so you have arbitration, lok adalat, you have mediation, you have conciliation. So that's alternative dispute resolution. Okay, that's very simple. Moving on to the next question, guys. Moving on to the next question. Which of the following is not a type of contract provided under the Indian Contract Act? Express contract, implied contract, unilateral contract, unexpected contract. I have never heard this term in my life. Unexpected contract. I've heard about an express contract. Something that is implied, implication. Fair thought. Unilateral contract. But never unexpected contract. Question number 22. Which of the following correctly differentiates tort and crime? A tort is a civil wrong. A crime is a criminal offense. Okay, a tort is a criminal wrong. No, sorry. A tort and a crime are not different. Absolutely, they are different. A tort and crime cannot be distinguished. Everything. Option A is the right answer. If you read the options, you will definitely, without fail, you will come to the right conclusion. Very good, guys. Very good. You guys are doing a very good job. Very good job. Okay. Moving on. Question number 23. Question number 23. Which of the following is correct regarding the doctrine of promissory estoppel? Prevents a person from denying his promise. Yes. Prevents a person from fulfilling his promise. This is not. It allows a person to make a promise without legal consequence. No, you have a responsibility under the law. It allows a person to break the promise without legal consequences. Absolutely not. Option A is the right answer. Option A is the right answer. Option A is the right answer. So simple. Is that clear, everyone? Am I clear to every one of you? समझ में आ रहा है आप सभी को? ठीक है, आगे बढ़ते हैं. चलो. The next question, question number 24. Which of the following is not a type of dispute resolution under ADR? Alternative dispute resolution. I said arbitration, conciliation, mediation. Litigation is going to the court. You are fighting in the court. That is alternative dispute resolution. If you go to the court, that is litigation. Am I clear? Everyone. Is everyone with me now? Okay. Question number 25. I'm so sorry. Very simple. That's how I did. It's so simple. Offer, acceptance, consideration, and free consent. Witness is not required under the Indian Contract Act for as an essential. Simple. These questions are simple. See, there is a difference between CLAT and symbiosis, Maharashtra CT and all. Keep that in your mind. Question number 26. Read the principle, read the facts. Master is liable for the wrongful act committed by the servant during the course of employment, provided he is doing that authorized act. Was the servant doing the authorized act? Yes. He was instructed by the principal, by the master, go to the airport, pick my friend up. Okay, come. While coming back, he picks up his friend also. And there is an accident. For the wrong committed by the servant during the course of employment, was he doing the authorized act? Yes, he was asked to do it. So, am I clear? Will the master be liable? Keep that in your question head. Now, I'll tell you this. Insofar as this question is concerned, CLAT says that the master is liable. That is what CLAT says. Now, SLAT, they have a different point of view. Now, CLAT के लिए आंसर क्या है? B is liable. B is liable for the wrong committed by its employees. But SLAT इस प्रिंसिपल के साथ कुछ और भी जोड़ लेता है और उन लोग का आंसर is little different. Their answer is option D. B is not liable because the tortious act was not committed within the scope of A's employment. But for CLAT, the answer is B. B is liable because employers are liable for the tortious act of its employees. Am I clear to each and every one? I can understand that there is a confusion. SLAT का रीजन कुछ और है, CLAT का रीजन कुछ और है. Both the answers. Am I clear? So since we are preparing for SLAT, your answer is A is not liable because the tortious act of picking up a friend from the airport was not committed within the scope of B's employment. But CLAT thinks it in another way. Am I clear? सभी को समझ में आया? Is that clear? See, for CLAT, the answer is B is liable. But for SLAT does not they do not think that, that picking up a friend from the airport is outside the scope of B's employment. That is what The answer says. Am I clear? Yes, topic is same, everything is same. I can understand. Is that clear? Is that clear, all of you? Okay. The next question, question number 27. Read the principle, read the facts. Sovereign immunity for the wrong committed by the army people, the government will be liable because they are the servant of the government of India. Okay, all of you? Yes, tell me the correct answer. Tell me the correct answer. And the correct answer over here okay, I agree with you. A lot of you are saying B. Yes. To my understanding, the negligence of the driver will make the government liable due to vicarious liability. I also agree. But that's the point of view that sometimes SLAT इन लोगों का गलती हो सकता है, जैसे क्लैट अपना क्वेश्चन पेपर का आंसर रिलीज करने के बाद भी फिर भी चेक करता है कि कोई अपने आप गलत दिया है क्या नहीं. स्लैट ये सब नहीं होता है और इसके कारण द ऑफिशियल बुकलेट सेज ऑप्शन सी इज द राइट आंसर. ऑफिशियल. Why? Now, see, to an extent, I also agree with SLAT's reasoning. The principle says that if you have to sue a government servant, you have to take his permission. Is that clear? Only insofar as that consent thing is concerned, they have used it. Am I clear? So, for your SLAT exam, option C is the right answer. Am I clear? Am I clear to everyone? Question number 28. See, these are all previous years of SLAT question paper. These were the questions that came. $28. The people who are deciding should be impartial. That's one of the basic principles of justice. The principles of natural justice says that, a judge should be like an umpire. He should not be from one party or the other party. Should not be related. Has he been given a fair hearing? No, he has not been given. So the correct answer is, am I clear? Is that clear to everyone? Is that clear? Very simple. This is very simple, I think. Not little difficult ones. Moving on to question number 29. For committing theft, the judge has given him death penalty, capital punishment. अरे किसी ने चोरी किया, उसको क्या फांसी देंगे? प्रिंसिपल ऑफ प्रोपोर्शनलिटी सेज कि आप जितना गलत करते हो उसका प्रोपोर्शनली आपको सजा मिलेगा. किसी ने चोरी किया, उसका क्या डेथ पेनल्टी हो जाएगा? एम आई क्लियर? See, it has to be proportional. It cannot be disproportionate. Am I clear? So the correct answer is theft के लिए आप फांसी दे दोगे. Is that clear? Okay. Everyone, समझ में आ रहा है? How to solve these questions? Question number 30. I think there is a spelling mistake. It is not road side of the road. A was driving on the wrong side of the road. B was driving with faulty headlights. Both collided. Injuries. So this is a case of contributory negligence, where both the parties have contributed to the injury. So both A and B have contributed to the accident. एक रॉन्ग साइड में चल रहा था, एक विदाउट हेडलाइट चल रहा था. दोनों का गलती था. दोनों का ही गलती था. Am I clear, all of you? How to solve these questions? Am I clear, everyone? Very good. चलिए आगे बढ़ते हैं. 31. Somebody does not want to get himself treated. Last stage of cancer, whatever. He does not want to be treated by the doctor. Right? The principle says A has a right to make decisions about his body and life. B is liable for administering treatment to A against his will. A has a right to make decisions regarding his lives and bodies. A's right to make decision regarding his life and body has been infringed by B. All of the above, I think. Option D is the right answer. All of the above. All of the above. Am I clear, everyone? Are you understanding how to solve these questions? That's important. You have a right over your body autonomy. Question number 32. Male 21, female 18 is the age below which, if you get married, it is void and illegal. Now, the earlier judgment said male is 21, female is 18. This one says male, female, both 21. Is the High Court judgment valid? Of course not. It is invalid. Absolutely, it is invalid. Am I clear? Are you understanding how to solve these questions? Am I clear? All of you? सभी को समझ में आ रहा है? Moving on to question number 33. So a particular government comes up with a law relating to dowry. Okay. Whether the husband and the in-laws will be held liable in case the legislature is silent about it. When you are interpreting a law, you have to understand the intention of the legislature or the intention of the parliament. Right. And the correct answer over here is both husband and the in-laws will be liable because the legislature is silent about who can be held liable. But the Supreme Court and the courts can interpret it. What was the intention behind banning dowry, penalizing dowry? The intention of the legislation has to be understood. Question number 34. The wife has given divorce. He says it is double jeopardy. Please try to understand. Read the facts carefully. Okay. Does this kind of a thing amount to double jeopardy? Of course not. Of course not. A has been punished by a court 14 years. The wife giving divorce is not a punishment under the eyes of law. So option B is the right answer. Is that clear? Moving on to question number 35. Prevents a party from denying a fact that they previously asserted. 4 लाख रुपया में मैं मेरा घर बेच दूंगा, अगले दिन बोल रहा हूँ 4 लाख रुपया बहुत कम है. Can he say no to that 4 lakh rupees? Because he made that offer. He cannot refuse to sell the property. He cannot. Are you understanding? So simple. देखिए, ये सब क्वेश्चंस आपको बहुत ज्यादा हेल्प करेगा इन योर प्रॉब्लम सॉल्विंग कैपेसिटी. Keep that in your mind. Question number 36. Strict liability. But did not cause any damage to anyone. Okay. But it says, principle says that there has to be dangerous substance, there has to be escape of that substance out of the premise and damage caused. But over here, but the facts say it did not cause any damage to anyone. So keep that in your mind. A is not liable under the principle of strict liability. As simple as that. As simple as that, guys. समझ में आया सभी को? ओके. देख लो. Okay. Question number 37. The definition of theft is provided. Whosoever intending to take any movable property out of the possession of any person without that person's consent moves that property out of the possession is said to commit theft. मालिक के घर से किसी ने सोने का हार लेके मूवेबल गुड्स को लेके कहीं छुपा दिया है कि अगले दिन परसों नरसों आके वो चोरी करके चला जाएगा. और शेयर करेगा वो proceeds of that gold chain with another servant. Has they committed that act of theft? Movable goods, did they move that goods without the authorization of the rightful owner with the intention of stealing? Yes, absolutely. Am I clear, everyone? Is that clear? So guys, if you are liking this session, do press the like button. Do press the like button. Question number 38. Okay. I sent my car to a garage. I bought it from someone who had no title, fair thought, but I bought it. I sent that car to a garage. Somebody else, believing that car to be his, takes that car away. Somebody does it. This is trespass of goods. If there is a physical trespass of goods, you are interfering with someone's goods. The moment Mr. Sharma took that car away or out, it is trespass of goods. Question number 39. The object of a particular contract, if the object is illegal, then the contract is void. They are into bid rigging agreement. They are trying to do something that is prohibited under the law. Competition Act. You are into bid rigging. Is the contract valid? Because they have an agreement, 12 of them have an agreement कि हम लोग 100 रुपया से ज्यादा नहीं बोलेंगे, बस सब लोगों ने कॉन्ट्रैक्ट किया है. And the object is to cause loss to India's exchequer. Coal India, India's exchequer, same. Did you understand? Did you all understand how to solve these questions? Okay. Moving on to question number 40. Question number 40. X tells B about C and says that X alleges that C is a cheat. You are making words, you're writing certain words intending to harm the reputation of a person, defame him. But there has to be publication. Did he publish that defamatory statement? Now, it was a closed envelope. It was a closed envelope, right? It was a pretty closed envelope. And hence, for SLAT, the answer is A. X is not liable since there is no publication. That is what SLAT says. Absence of publication. There was absence of publication. Question number 41. He says 50 lakhs, somebody said 45 lakhs, so the offer is over. You did not accept. Later on, he sells it to someone else. Because acceptance must be absolute and unqualified, means it has to be absolute, it has to be the mirror image of the offer. The correct answer is Nitin was not bound to sell his house to Ramesh. He was not bound because he made an offer of 50 lakhs. The acceptance he got is for 45 lakhs. The law says it is not an acceptance. He sells it to someone else. Question number 42. MC Mehta versus Union of India laid down which of the following principles, okay, of law: hazardous liability, absolute liability, strict liability, conditional liability. Tell me which is the correct answer. Which is the correct answer? It is C. Strict liability is Ryland versus Fletcher. Okay. Absolute liability is MC Mehta. MC Mehta. Bhopal gas leak tragedy. Bhopal gas leak tragedy. Everyone. Question number 43. Which of the following is correct relating to fundamental rights? Fundamental rights are not justiciable. They are is correct. Okay, this is not correct. Fundamental rights are justiciable. Okay. Fundamental rights are part of basic structure of the Indian Constitution. Okay. So, एक second. Fundamental rights are not justiciable, ये तो गलत है, so option A हटाओ. Fundamental rights, yes, if there is a violation of your fundamental right, you can go to a court. That is meant by justiciability. Fundamental rights are part of basic structure of the Indian Constitution. Yes, so B and C. Yeah. B and C. Both B and C. Is that clear? So did you understand how to solve these questions? Are you understanding? Very good, all of you. 44. Which of the following is correct regarding directive principles of state policy provided under the Constitution? DPSPs are non-justiciable. True. DPSPs are sometimes justiciable. No. False. DPSPs are justiciable, but not fundamental rights in governance of the country. False. DPSPs are justiciable and fundamental in the governance of the country. False. DPSPs are non-justiciable. This is the only true statement. This is the only true statement. Option A. Which of the following is correct? Only option A. Only option A. Question number 45. Doctrine of severability is provided under which article of the Indian Constitution? Yes. Suppose there is a law. Suppose there is a law which was made in the year 1872. Indian Contract Act. If after the Indian Constitution came into being 1950, if there are two sections, two provision of a law which is violative of the fundamental rights, then that only those laws which are in contravention with our fundamental rights will be struck down. That is given under Article 13. That is Article 13. When a provision of a statute is against the Constitution, the same is servable. You can separate them from the rest of the law, rest of the statute. That the offending provision shall be declared void and not the entire statute. Am I clear, everyone? Am I clear, everyone? Okay. Moving on to 46. Directive principles of state policy in the Indian Constitution has been borrowed from which of the following constitutions? Yeah. Please give me the right answer. Everyone. सबको सही आंसर देना पड़ेगा. It is from the Irish Constitution. Okay. Irish Constitution or Ireland. Okay. Directive principles of state policy, nomination of member in the Rajya Sabha, methods of election of the president, they have all been inherited in India from the Irish Constitution. Moving on to question number 47. Who amongst the following administers the oath of the office of the president and every person acting as president while discharging the functions of the president? Who administers oath to the President of India? The Chief Justice of India. The Chief Justice of India. Very important, okay? Do keep this in your mind. The Chief Justice of India. Did you all understand? Question number 48. Principle of double jeopardy. No person should be punished twice. Now, किसी बंदे ने थेफ्ट किया, उसका क्रिमिनल लॉ में पनिशमेंट भी हो गया और अपना जो नौकरी क्षेत्र है उधर में भी उसको सस्पेंड कर दिया, उसको टर्मिनेट कर दिया. Will it be double punishment? Can it be double jeopardy? The answer is no. The decision of the committee is valid because it does not amount to second punishment. Absolutely. Is that clear? All of you? Next question, 49. Self-incrimination. I cannot be forced to be a witness against myself. Okay. A document concerning Mr. X, a document concerning Mr. X was in dispute in the court. In order to match the finger impression, matlab witness ka finger impression of that document with that finger impression of Mr. X, the court asked Mr. X to come and provide his finger impression. Mr. X denies, stating that he cannot be compelled to be witness against himself. He cannot be compelled to be a witness against himself. Okay. The correct answer is, by calling Mr. A to give his finger impression, the magistrate has compelled him to be a witness against himself. Okay, moving on to the next question. Damnum sine injuria. Damage. Injury. Violation of a legal right with damage. Damage with violation of a legal right. Damage without violation of a legal right. Option C is the right answer. Damage without injury. There is a loss without violation of a legal right. Gloucester Grammar School example. Gloucester Grammar School example. Tuition. Somebody opens up a new school next to another school. The old school suffer loss because of the new school. Right? Am I clear? So guys, if you have watched today's session properly, you understood this session, then do gives it a thumbs up. Okay? Do just press the like button and share this video with your friends. So that is option C is the right answer. Damage without injury. So guys, BYJU'S exam prep brings to you a free workshop. Is it too late to start preparing for CLAT 2024? This free workshop is going to take place on the 7th of May at 6 p.m. by Abhimanyu Rajpurohit. BYJU'S exam prep brings to you get up to 90% scholarship on all our preparation program. The date is 30th of April at 11 a.m. So hurry up and register now for this scholarship test. BYJU'S exam prep, as you guys know, brings to you a comprehensive course for CLAT 2024. Secure a seat at your dream NLU. 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law entrance examination along with video solutions, monthly e-magazine for current affairs, and the entire content is curated based on our extensive analysis of the last 5 years of CLAT question paper. So guys, this brings to us the end of the session. I hope you enjoyed it. Do subscribe to our YouTube channel. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And do not forget to download the BYJU'S exam prep app. So with this, we come to the end of this session. Thank you very much. Do like, do comment, do subscribe, and do share this session with your friends. Bye-bye. Take care. Have a great evening ahead. Bye-bye. And all the best, all the best, all the best to you all the best.